Hello friends, welcome to Legal Learning. So today in this video we're going to discuss about role of judiciary to maintain federal structure. Role of judiciary to maintain federal structure. And also we're going to discuss about three more concepts, that is number one, judicial review, judicial activism and judicial overreach. So first of all we need to understand what is like organs of the government. So there are three branches of the government, that means three organs of the government. Judiciary, that is independent, impartial and integral. It is the watchdog of the constitution, it is the guardian of the constitution, protector of the rights of the people, protector of the fundamental rights of the people, and it is autonomous, that means it is independent. And there are three levels. We have first of all Supreme Court, that is at the apex level, then High Court, there are 25 High Courts till now, and subordinate courts. Done. So this is the structure of the judiciary. Judiciary is very important for a democratic country. In our country, judiciary is the strongest wing and strongest organ of the government, and independent of all these two other organs like legislative and executive. Done. So now what is legislative organ of the government? Legislature is what we can call parliament at the central level, and state legislature at the state level. Parliament, it is union level, state legislature, it is state level. Like parliament consists of two houses, House of the People, that is Lok Sabha, lower house, and Rajya Sabha, that is Council of States, which is upper house. Done. So this is legislative. What is the main function of the legislative? It is to make law. And another organ, another residuary organ is there, that is executive. Executive maintains the administrative matters. It is the residue of legislative, and it implements policies, enforces and implements policies. So this is the function of the executive. In India, these two branches, legislative and executive, these are quite there is no strict separation. For example, I'm explaining this as well. Like for example, how these are similar. Now Prime Minister is the head of the majority party that wins the election, and Prime Minister acts on the advice of Council of Ministers. But we have President, and the President also acts on the advice of the Council of Ministers. That means President is the nominal head, it is not the real head. The real head is the Prime Minister. So there is some overlapping between legislative and executive. President is the executive head, and Prime Minister is the head of the legislative head. So but they are quite, President acts on the advice of the Council of Ministers, that is headed by the Prime Ministers. That means there's President do not enjoy the absolute power. Okay, so there are some similarity, but judiciary is independent. Judges are not bound to anyone. Like judiciary is independent. So these are the organs of the government. Okay, I took a lot of time to explain these concepts. So now let's move to other things like federal structure of the government. Now I'm going to explain you federal structure. Okay, so federalism. In federalism, there are two government. One is central government, another is state government. And as we discuss about powers, powers are legislative powers, administrative powers, and financial powers. These powers are equally divided between these two governments, central and state, just like Article 245 of the Constitution of India, just like Schedule 7. In Schedule 7, there are three lists: List 1, List 2, List 3. List 1 union list, List 2 state list, List 3 concurrent lists, and another is there residuary list also there, Article 248. So now in every list there are certain subject that mentioned there, and only that government has power to make law in respect to the subjects mentioned in the particular list in Schedule 7 of the Constitution of India. So this is about the list. Now we have to quote AVDC to explain federalism. So if you quote definitions in the exam, then it's much better. So let's see what is federalism. Now our topic is role of judiciary maintaining federalism in India. Right? Okay, so first of all we need to understand the meaning of federalism. As I have explained, it is division of power between central and state. The powers can be legislative, administrative, and financial powers. So federalism means legalism, the predominance of judiciary in the constitution, the prevalence of the spirit of legality among the people. Now in the words of DC, how judiciary comes into play here in the federal structure is that, as in the words of DC says that federalism means predominance of the judiciary in the constitution. predominance of judiciary in the constitution. So judiciary should be powerful in the constitution. How? I am going to explain two more concepts here. One is, now we know constitutional sovereignty and parliamentary supremacy. What are these concepts? In constitutional sovereignty or supremacy, the Constitution of India is supreme. Parliament has limited power in case in constitutional supremacy, and it talks about limited government. That means it limits and restrains the power of the parliament. Okay, so India follows this concept called constitutional sovereignty or constitutional supremacy. That means in India, under Article 368, which is amending provision, Parliament exercises very limited power of amendment. Parliament cannot do anything beyond the power of the Constitution. If Parliament amends any law that is beyond the power of the Constitution, that the judiciary has the power under judicial review to declare that thing as null and void or ultra vires. That means beyond the power of the Constitution. That means in India, Parliament is not, in simple words, in India, Parliament is not supreme. In India, Constitution is supreme. But in case of Britain, Parliament is supreme. Anything passed by the Parliament cannot be challenged in normal cases. So Britain enjoys parliamentary sovereignty or parliamentary supremacy. But in case of India, we have constitutional supremacy. So that's why it is said that to maintain a federal structure, like in the case of USA also, some countries like USA and Canada, the concept of federalism has been evolved from USA and Canada, because in case of USA there are various states. All states came together, made an agreement, and thereby they formed United States of America, United States of America, that is called USA, and their federal government is also there and state government is also there. So this is the traditional model of federalism, and Canada is also similar. But in case of India, there are some certain exceptions are there in India. India follows certain exceptions. That's why India is called quasi-federal system. Quasi means not strictly. India is not strictly federal country. Okay, now features of the federal system in India. What are the features of federal system in India? That's it. First of all, center and states, as I have already mentioned, and 3 lists are there in the Schedule 7 of the Constitution of India. These lists are Union list, list 1, state list, list 2, and concurrent list 3. And there are many subjects are also there in those lists. So what are the features of the federalism? Supremacy of the Constitution. In federalism, the Constitution is supreme. In case of USA also, the Constitution is supreme. But in case of Britain, it is parliamentary sovereignty. So Parliament is supreme, and there is no such federalism in Britain in the strict sense. So the Constitution is the supreme law of the land. Independence of judiciary. In India, we have independent, integral, impartial judiciary, and as I have already mentioned in the beginning of the video, the role of judiciary, that is the watchdog, that is guardian and the protector of the Constitution of India, protector of the rights of the people. So then comes agreement. An agreement between independent units to relinquish their authority for the sake of common interest and keep the residue of the authority in constituent units. I have explained this concept as well. For example, in case of USA, that is called United States of America, many states came together, made an agreement with the central government, and thereby they agreed to be part of the greater, like it is similar to USSR also, like they agreed to be part of that United States of America. But in case of India, there was no such agreement. The center was strong and there was no such agreement. So Indian federalism is indestructible. That means it cannot be destroyed. The agreement cannot be breached or destroyed. So Indian federalism is it is integral, right? It is quite different. Then comes distribution of powers. As I have already mentioned, distribution of 3 kinds of power: legislative, that is lawmaking power; administrative; and financial powers. Okay, then judiciary and federalist nature in India. So now this is our main point: judiciary and federalist nature in India. The Supreme Court of India has held that the federalist nature of our country is part and parcel of the Constitution. Federal, okay. Then integrated system. What are the federal features? Like integrated federalism is a midpoint between unitarist, which has a supreme center in which the states are subordinate, and confederacies wherein the states are supreme and are mainly coordinated by the weak center. So there are 2 kinds of federalism. One is unitarist, in which states are subordinate and center is strong, and confederacies in which it is the opposite, means it is the reverse. That means states are strong and union is weak. But India is a midpoint between these two. India is, if this is unitarist, if this is confederacies, India falls here in the scale, midpoint. Then equality of power. In India, powers are equal, like the powers of the High Court judges and Supreme Court judges are equal, and here High Court judge not being subordinate to the Supreme Court judge. Powers are equal, integrated judiciary. Supreme Court has on many occasions reiterated the position that Supreme Court is the superior to the High Court only in appellate cases, because appeal lies to the Supreme Court from the High Court. Otherwise, the powers are same. This balance exists from independence onwards. Okay. However, it has been titling in the favor of the central court. So favor is going towards the central court, apex court. But the need for this balance was underscored during the emergency, when the High Court, a significant number at least, stood out as beacons of freedom, even as the Supreme Court failed in this duty. Okay. Now, in the recent years, three specific trends have greatly eroded in the standing of the High Court, leading to an imbalance in the federal structure in the judiciary. How the imbalance is occurring? First of all, the Supreme Court, or rather a section of judges called the Collegium, has the power to appoint judges and Chief Justice to the High Court. We know the Collegium system. Many judges, the Supreme Court judges, has power to appoint judges of the High Court, and Chief Justices also of the High Court, and the Supreme Court also. So this Collegium has also has the power to transfer judges, not only appointment, not only they enjoys powers in regards to appointment, but also in regards to transfer also. So second, successive governments have passed laws that create parallel judicial system of courts. Parallel judicial system of courts and tribunals, which provide for direct appeal to the Supreme Court, bypassing the High Court, just like tribunals. Tribunals, many tribunals are there, like National NCT, National Company Law Tribunal. I forget the term. So third, Supreme Court has been liberal in entertaining cases pertaining to trifling matters. Liberal in entertaining cases, even if it is trifling matter. So this happening, that means there is imbalance. Although there are imbalance in three ways, as given here. Centralization and effects. This has inevitably led to the balance tipping in favor of centralization of the judiciary. The judiciary is also becoming centralized. Not only the central government is becoming stronger in India, but also judiciary is also becoming more centralized. Powers are being concentrated in favor of judiciary more. It is not distributed, but it is being concentrated. So the greater degree of centralization of the judiciary, the weaker federal structure. So this is the matter of concern. Relationship between federalism and judiciary. What relationship? In India, judiciary has a considerably important place. Okay, independence of judiciary. What are the important place judiciary enjoys? Like civil liberties, protects the civil liberties, and what part? And details provision of judiciary is given under Part 5, Chapter 4 of the Indian Constitution. It discusses Indian judiciary, and Part 6 of Chapter 5, it is reverse, 5, 6, 6, 5, part and chapter. So talks about High Court and subordinate courts in the states. Now the authority of the Supreme Court of India is 5 to 6, 6 to 5. It is reverse, you can remember it in that way. So the authority of the Supreme Court of India is constitutional, civil, and criminal. It has given originate, appellate, and advisory jurisdiction. If you open the barrack, you can find all these provisions. The wide jurisdiction of the Supreme Court can be further widened by the Union Parliament. So Article 32 and 139 are particularly important for understanding where judiciary stands with respect to the federal system. The former provision provides right to constitutional remedies, Article 32. And Article 139 is about what? And for moving the Supreme Court for enforcement of fundamental rights in case of violation. Then Supreme Court is also empowered to issue writs in the nature of habeas corpus, maintenance, prohibition, quarantine, and certiorari. Part 3 of the Constitution in violation of Part 3. These are the writs, as I have already mentioned. The power falls under both original and appellate jurisdiction. guardian of fundamental rights, the command of the apex court is not exclusive but concurrent and final. It is not exclusive but concurrent and final. That means High Court also has similar power to 26, and the power of High Court is wider than to the Supreme Court. Dr. B.R. Ambedkar said that Article 32 is the most important part of the Constitution, without which entire document will be nullity. He considered it heart and soul. You can write this in your exam, heart and soul. Dr. B.R. Ambedkar said Article 32, heart and soul. This is heart and this is soul, and this is our B.R. Ambedkar, and he said it heart and soul of the Constitution of India. This is the greatest safeguard for the safety and security of the individual. Okay, so we are understanding the role of judiciary, right? It is the basic role of judiciary. You can write this in exam. The answer won't be that much complicated. The question looks complicated, but answer is easy. So we can quote one case, Ramesh Thappar versus State of Madras. How to remember Ramesh? For example, there is a person named Ramesh and Thappar. Thappar means this is slap versus State of Madras. In the State of Madras, Chennai, that means South India. Ramesh Thappar was slapping someone in the State of Madras in the year 1950. Remember it like that way. AIR 124. Okay. So in this case, the Supreme Court opined that Article 32 accords a guaranteed remedy for the remedy of fundamental rights, and the remedy itself is a fundamental right. Article 32 itself is a fundamental right. So this is an interesting thing, and you know, you have read it in your constitutional law in your LLB first semester, right? It's nothing new for you. And the remedy itself is a fundamental right. Thus, the court, as a protector of the fundamental right, cannot refuse to entertain responsibility to entertain applications against the infringement of such rights. Okay, done. Then Supreme Court has given other important decisions on the like in the following cases. What are the cases? Let's try to remember. Keshav Madhav Menon versus State of Bombay. Now we need to remember the cases also. So we'll use some technique. This is 1950 Ramesh Thappar versus State of India. 1950 AR 124. Keshav Madhav Menon. Keshavan Madhav Menon versus State of Bombay. B. Bombay. After Madras, let's move to the B. Bombay. MB. B. Another is State of West Bengal versus Anwar Ali Sarkar. As the title itself says, that person might be Bengali, so State of West Bengal. 1951, it follows a chronology, 1951 to 1952. Then Chandrajit Lal Chaudhary versus Union of India, 1951. A.K. Gopalan versus State of Madras, 1950. We know the case of A.K. Gopalan and Maneka Gandhi. Then Dwarkadas Srinivas versus Solapur Spinning and Weaving Company, 1954. These are the cases. So this is done. The topic ends here. After that, we have topic of judicial review, then what? Judicial activism and judicial average. I'll deal with all this topic in our next video. Thanks for watching. This is the last minute revision before the exam, and the material I followed here is IS score. This is the material. You can download it in from the internet, and you can follow it. Thank you.